Hello, everyone. My name is Michael Liptrot. I'm an attorney here at Tully Rinckey, and I was just hoping to share with you today some of the basics about divorce mediation, just a real overview about what it is and who it can help, how it can help, why it can help as an alternative to traditional divorce disputes. So we'll go ahead and a little bit about me. For about the last 10 years, I have been an attorney practicing mostly in family law. That's matrimonial cases, divorce, custody disputes, child support, spousal maintenance, all that kind of stuff. But I also have been certified in divorce mediation, and I've been working on expanding that part of my practice. I have been a member of the New York State Council on Divorce Mediation, and I do believe that it is an appropriate method of dispute resolution in a lot of divorces, and a tremendous benefit to some people who can find mediation and are in the uh, you know mind space to pursue it. So all right. So the topics we're going to cover today, we're going to do a little overview about what mediation is, and how it's a little bit different from traditional litigation, the role of the mediator in a mediation, the role of the parties, what they're responsible for, and wrapping up mediation after successful mediation. What does successful mediation look like? And what happens once mediation is over? All right, so we'll dive right in here. So, what is divorce mediation? Mediation is a type of alternative dispute resolution. It is one of several types of alternative dispute resolution. Other types you might have commonly heard: arbitration, having a neutral evaluation if sort of a subject property or asset is the thing in dispute, and then also collaborative law, which is where the parties in collaborative law, the parties would sign up sort of to have their representatives uh, with them in the process, and other professionals get involved in specific areas. You'd have forensic financial experts getting involved in the financial aspects, perhaps a therapist or a psychologist gets involved, in custody visitation issues. Collaborative law is very different from mediation. They're all very different. There's also, maybe people have heard of parenting coordination. It's not really alternative dispute resolution, but it is sort of an alternative to going to court. But so mediation is one of these areas, these growing areas of alternative dispute resolution, rather than just heading to court and letting a judge decide. In the specific case of divorces, mediation is an alternative to the quote unquote contested divorce, which is, one party files the summons and complaint and serves it on the other party, and you're off on your way to court. Um, with mediation, there is no court. There's no judge. People are not adversaries. They're not opponents in a case. It's a much softer process. It's definitely less formal, and subsequently is less stressful. Parties are required to cooperate in order for a mediation to be successful, and they are working together to take an individualized approach to resolve the issues that are before them, in order to reach the ultimate goal of getting divorced. Mediation is voluntary. Parties are not required to go to mediation or attend mediation, but the courts in all areas of law, and especially in divorce, are supportive, and they are increasingly supportive, and they're coming up with new ways every year to push people to at least give it a shot. There is an Office of Alternative Dispute Resolution in the New York Unified Court System, UCS. Part 146 governs the Office of Alternative Dispute Resolution, and they are also tasked with appointing attorneys, who are qualified to have the requisite training and requisite number of hours of private mediation. They are impaneled by the court to serve as low-cost or no-cost mediators as sort of a first foray into mediation for some parties. Also, in the case of divorces, if you are filing for divorce, if anyone has any familiarity with contested divorce proceedings, the first time you go to court in a litigated divorce case, it's known as the preliminary conference. And at the preliminary conference, you fill out a form order, which is the preliminary conference order, which basically sets forth the discovery schedule. But one of the things that's included in the divorce preliminary conference order is an affirmation by the attorneys that they have advised their clients of mediation as an option to them, and that the parties are aware of mediation and have at least considered it. It's a box that you check on the form, but it indicates the court's support for this method because the courts are increasingly less capable of handling the caseload that they are burdened with year after year. So how exactly is mediation different from a traditional litigated case? You can see my bullets here. In a contested divorce, spouses are opposing parties. Each party is taking a position. One is the plaintiff, one is the defendant. In divorce, plaintiff, defendant, the distinction is not so important. They both have positions, and they both have requests, and their positions are more extreme maybe than necessary because in the goal of litigation, it's sort of this all or nothing mentality. You either win or you lose, and if you are, even if you might be looking for joint custody, you both, for purposes of litigation, you're both going to say, I want custody, primary custody or sole custody of the children, and then you cross your fingers and hope that a judge is going to decide in your favor, or that under the stress of an all or nothing high stakes court proceeding, you're able to have the space of mind and the time to make some sort of agreement. In a divorce case, you file a summons and complaint that requests for judicial intervention to get a judge involved in your case, and a judge gets assigned to your case. You don't get to pick the judge. You don't get to fight over the judge's rules and timelines and preference for how to move a case along. And if your next court appearance is on Tuesday at 10 a.m., you have to show up Tuesday at 10 a.m. It doesn't matter what kind of appointments you have, what kind of work schedule you have, it's out of your hands. And that's just control over the case. There's also sort of a control over which is more of a psychological thing, but there's control over the language of the case. You have to use the legal jargon, the legal language that's used in the court system. Like I said, both parties, you have a plaintiff and a defendant. There's burdens of proof. There's discovery orders, and I put sole custody in quotes there. That's just a term. That's a legal term, and for some people that carries great psychological weight. Fighting for sole custody, or wanting 50-50 custody. A lot of people say, I want 50-50 custody, and they don't really know that that's technically not a legal term. The courts don't say 50-50 custody, and what 50-50 custody means to that individual might be different than what it means to another individual. But once you're in the court system, you have to use their language. You don't get to, create your own terms. There's also a risk in litigation of, permanent resentment to the other spouse, I think for obvious reasons, and it can damage a parental relationship in the case of families. You're putting kids through this process as well as the parents or the spouses. In mediation, it's a lot different. People have an issue. You know, they know they're going to get divorced, but how are they going to do it? Uh, in mediation, you're looking for that mutual um, resolution, a collaborative effort to resolve these issues of the divorce. There's no winners, there's no losers, and mediators create a space where they're using language that's tailored to the particular participant's needs, um, and you're trying to figure out solutions that fit the particular situation. Something that's going to work for both parties, something both parties can understand and get behind, and parties are going to walk away from a mediation, a successful mediation, feeling that they've been heard, they have absolute control over the process, and they have created an agreement that they understand. You know, if they're making concessions, they understand why they're making concessions, and they're not feeling forced by a third party or some law on high saying what should be. Common issue here of how to distinguish how mediation is different from contested divorce. I would say the issue of child support and spousal maintenance really highlights this here. In the court system, if anyone's had to deal with this, you'll know spousal maintenance for a few years and child support for many years has been subject to guidelines, calculations. It's a formula. It's based on the parties' incomes. It's even further than that. It's based on the parties' last filed tax returns, right? Unless their current income can be shown, should be credibly used in lieu of their last filed tax return. You get a lot of complaints, people talking about their last filed tax return. Well, overtime shouldn't be included, etc. Um, in the court system, they don't really care about your excuses. The law is the law. So they plug your income into a formula there, last filed tax return, what does your gross income show? And the formula spits out a number, and that is the quote unquote presumptively correct amount of spousal support, if spousal support is owed, and child support. Um, and it is a formula, and the courts like formulas because they're easy, simple to apply. There are factors that the court must consider about whether to deviate, but you can imagine once you have that formula, once you have that number spit out at the end, um, very difficult to change, and very rarely will a court uh, pick a number that's different than the presumptively correct amount of spousal support or child support. In mediation, um, it's really the reverse. By law, you have to set forth what the presumptively correct amount of support would be if it was left to a court, but you don't get to that number. You definitely don't start with that number, and you don't really require. Can you still hear me?
Yes, you just cut out for a second. So if you
Oh,
want to go back like a sentence.
okay. Yeah, because I see my video now. Anyway, Um, so I was saying in mediation, it's much different. The process for determining spousal support and child support is based on the party's budget, based on their need. You're not talking about what the presumptively correct amount of support is going to be based on your incomes in some formula. You're going to start with the spouse, move out of their marital residence and into separate homes. It's two families. You had a single household with maybe two incomes. Maybe one income is higher than the other, but you have two incomes supporting one household. Now you have uh, one income in each household supporting two homes, right? So mediation, that financial aspect, the budgeting aspect, spousal support and child support determination. Both parties understand why they're paying the support. Some very unhappy clients in court talking about child support, where if you have three children and the other parent gets designated the quote unquote primary residential parent, now the other parent has to pay child support, and it's just a formula, and it's 29% of their gross income. That's a lot of money for some people, and it's an impossible amount of some people for some people to fathom how much that much money can go to child support. Now, you might in mediation, after budgeting and talking about your finances, um, and what the parent, where the children are primarily residing, what that parent really needs, you end up getting to a number, and then you might find parents' gross income, and they're paying maybe close to or relatively correct calculation, but the way you got there, you have explained it, and they understand, children are expensive, and this is what needs to be paid in order to support. So, unlike in court, mediation gives the parties an opportunity to talk about what really matters to them. Parties have a limited, very limited opportunity to speak in court proceedings. They've hired attorneys. The attorneys are going to do their job. They're going to do most of the talking. But the only time, litigants get to speak in the court proceeding is probably when they're testifying under oath in a trial, right? They're not really going to have a chance to speak. They're going to give the judge their peace of mind while the court case is pending. So in mediation, you really get to talk about what matters to you. You don't have to. It doesn't even necessarily have to be totally relevant to the literal issues of the divorce. You just sort of air it out with the other parties so that everyone can have an understanding about where they're coming from and what they need to move forward. Another difference is courts only grant certain kinds of relief. That they have there's very specific issues attendant to the divorce that they need to resolve, and they have traditional ways of resolving those issues. A big example of this is health insurance. Health insurance is automatically, by law, discontinued once the judgment of divorce is signed. A former spouse cannot remain on their divorced spouse's health insurance. It's just by law, not relief that can be granted. In mediation, you could fashion some sort of agreement where the parties agree to remain technically married by not filing those divorce papers right away for 6 months, 9 months, 12 months, whatever the non-titled spouse needs to remain on that health insurance, but before the judgment of divorce is actually signed. Another common issue is one party remaining in the home with the children for a certain period of time. Courts do sometimes grant this relief, but it's only in very exceptional circumstances. So if you're in mediation, maybe you don't fit the traditional court standard for remaining in the home. They say, okay, this house is in joint names, it needs to be sold, and you have to figure it out moving forward. But if one party really wants to stay in the house for the kids, that can be discussed in mediation, and that can be put into an agreement. Another thing that courts are not going to do that could be done in a mediated agreement is one spouse could agree to pay specific bills, auto insurance or the utilities on the home, in lieu of spousal maintenance or a reduced spousal maintenance payment or a reduced child support payment. You could mediate that issue if that's what's important to the spouse who's paying, is that he or she wants to make sure certain bills are getting paid. You could work that out in a mediation. So a mediated agreement is going to look very different from even what a settlement agreement looks like in court, because when you're in court, you're tied to the traditional solutions. Okay, and then this is a little note about should everyone mediate? It's more maybe it should be could everyone mediate? And just a little blurb. Mediation is low cost, efficient, and generally more pleasant process than traditional divorce litigation. And most couples would benefit from attempting mediation at least, rather than going straight to court. But mediation is certainly not appropriate in some cases, and that is where there's significant disparity, a power disparity in the relationship, some sort of power dynamic that makes it impossible to fairly mediate an agreement. That would be in situations involving a history of domestic violence, past or present, where one party is just going to be exercising undue influence over the other party. That mediation is not going to be appropriate there. And then also where one or both parties are not, they either are not in fact trustworthy reporters of their finances, that they're intentionally withholding financial information, or if there's such a significant just lack of trust, founded or unfounded. There's a lack of trust there. People are not going to be able to effectively mediate their agreements. I will say, in the case of high conflict couples, mediation can still be an option, even if you really are not on favorable terms with your spouse, and every conversation devolves into a shouting match. There are ways to get around that in mediation, and it's still an option. Even in high conflict cases, it's still an option. Even where it's a custody is a significant issue in the case, mediation is an option. But I would say it's definitely not appropriate in every case in these exceptional circumstances. Okay, so we talked about how it's different from litigation, but why would you do it? The financial cost may be apparent. You're paying for one mediator for both parties to facilitate your communication and cooperation towards a resolution of your divorce, versus hiring two attorneys whose goal is to zealously advocate on your behalf and maximize the benefit of your objectives. So even in some cases, parties frequently will hire attorneys in the course of their mediation, either to provide advice before or after mediation sessions, or you hire an attorney at the end of the case to review the final agreement. You are going to be paying far less to have an attorney provide you advice than to advocate for you in court. There aren't going to be multiple court appearances, right? There aren't going to be multiple motions filed. There aren't going to be constant conversations and emails running up a legal bill. So the financial cost is not not as great in a mediation versus litigation. There is an emotional cost to litigating. There is emotional turmoil from the spouses, the children, and even relatives in the course of a divorce, in a hotly contested divorce. Mediation can save you from this. I think even trying mediation could save you from this, even if the mediation fails and you have to go to court. Having had the experience of at least attempting to communicate and cooperate and see the situation from your spouse's perspective can temper the emotional cost of litigating the divorce. Mediation encourages the spouses to collaborate and communicate with each other. Nobody is fighting for custody. You're not subjecting your children to the stress and rigor of custody battle in court. Even in a court proceeding that is not where custody is not hotly contested, if it's an issue, an attorney is going to be appointed for the child or the children, and that is necessarily going to involve the children in the court process, maybe more than some parents would like them to be involved. And if there's mental health issues of one or both parties or the children, or there's some issue of alienation of a child or something like that, the court might go so far as to order a forensic evaluation, which is going to involve a psychiatrist, analyzing the parties and the children in an effort to determine which of the parents is more fit to be the primary custodial parent. So that's certainly a great emotional cost compared to mediation, where you have parents discussing, what kind of arrangement would be in the best interests of their children. There is a time cost to both mediation and litigation, but mediation is usually more efficient, and you're going to get the mediation completed quicker than if you took the time to litigate the issues in court. Like I said, there's discovery orders they can put in place. You have hired attorneys. You have to get them your documents, and then they have to get their documents to the other side. They have to review all this information. There's motions get filed, then they get put on the judge's calendar. Then, there's a procedure for opposing the motion and replying to the motion and having oral argument. And then, if a hearing is necessary, you're putting that on the calendar as well. And it's not the litigant's calendar, it's the court's calendar, right? So, and if you're heading all the way to a trial, you are in for a long ride if you're going to litigate the case. In addition to the actual length of time, you're also sort of choosing the timing and the pace of a mediation as opposed to going to court. You go according to your calendar. You prefer mornings, or you want to do sessions once a week or once a month. You need time to get your finances together and submit that to the mediator to share at the next session. Life gets in the way, and you can be busy, and the mediation is only going to last it's going to take more time if the parties need more time, right? That's really the difference. You also should choose to mediate. This sort of ties back into the time cost, but you have control over the process. You're not just choosing the timing, you're also choosing the manner of the mediation, right? You don't get to choose your judge, but you do get to choose your mediator. And you also get to choose sort of how you're going to resolve each issue. We're going to go over all the issues in a couple of slides, but there are certain issues that the court determines are more pressing, right? Issues of custody and visitation have to be determined first in a litigated case. The court puts priority over sort of getting that issue out of the way. But if you are two parties who are just relatively getting along, and you're more concerned about the finances, in a mediation, you can choose to deal with the finances first. Maybe you're anxious to move out and be separate, and then deal with everything else later. You can work on your budget first, and how you're going to support two households first, and then deal with the other issues. This control over the process also has the added benefit of parties being more likely to abide by the agreements they make, as opposed to a court order telling them what they have to do. They've made an agreement saying what they've agreed to do. So you're more likely to avoid your other spouse violating the agreement, sort of on principle or because they disagree with the order, and then you have to go back to court for enforcement. And another reason to mediate is it's confidential. Everything in mediation is confidential, with the exception of really specific instances, which would be, reports of harm to a children, threats of future harm to another person. Mediators cannot be conspirators to an ongoing crime, right? So that, it would have to be reported, but not really what you think of in a traditional case. Those are exceptional circumstances. But the heart of the mediation is confidential. Mediators cannot be called upon to testify in court about what was discussed. The parties cannot be subpoenaed to disclose what was discussed. The concessions that are made in the event of a failed mediation and people head off to court, the concessions that were made or facts that were admitted in a mediation won't be used against you in a future proceeding. Any information that is shared, documentary information is not admissible in the court as evidence. So all that's to say, you can have confidence to have open and honest communication in a mediation, knowing that if it doesn't work out, and things do have to work their way through the court system, you are not prejudiced by having at least attempted mediation. Okay, the process. So couples are going to meet with a mediator over the course of several sessions. The sessions are chapter-based, based on the issues that are going to be resolved. So you have, in a traditional, if it's applicable, you're going to have custody, child support, spousal support, division of assets, division of debts, and the issue of court fees to get the divorce finalized. These are all issues that the court requires you to resolve before you get divorced, if they're applicable to your case. So in the course of the mediation and the sessions, you're going to disclose financials. The mediator is going to guide the parties through the mediation, facilitate discussion between the parties, and it is the parties who are going to make the decision. The mediator is a neutral third party, attempting to remain objective, not taking sides in favor of one party or the other, but really to explain, maybe how things work generally and explore other options that might be available to the parties and what might make sense based on their circumstances, and the individual participants in the mediation. They're going to be the deciders about how the issues are going to be resolved. Sessions then continue chapter by chapter until all the issues are resolved. And once we reach resolution, an agreement, formal written agreement, or a what's known as a memorandum of understanding is prepared. And then there's one final step. It's not really part of the mediation. It's really a necessary second part, which is to file the divorce paperwork in order to get divorced. Okay, so this is just a little bit more of an explanation here. In the case of no-fault divorce, that's what, in New York, when you file for divorce, you're filing under a no fault. And the courts require that it's part of the statute. All issues related to the divorce must be resolved in order for the court to grant a divorce. So all the issues depends on your case, but we just spoke about this: custody, visitation, child support, spousal maintenance, that's spousal support or alimony, equitable distribution, that's division of assets and debts, tax issues to the extent that they're applicable, past, present, future tax issues, and the issue of fees, court fees. A little bit about mediation. Sessions are going to be 1 to 2 hours. This is, again, within the control of the parties. There's no hard and fast rule, but you want to have enough time to have a substantial discussion, and you don't want to have too much time that people's brains are fried by the end, and they need to be able to have a coherent state of mind in order to really wrap up, reach a resolution on each issue as you proceed. The goal of every mediation is to reach mutual decisions, mutual agreements, and it is the participants who make those decisions. It's not up to the mediator. Nothing is left up to the mediator. Compare that to a contested divorce where you have parties making their most creative, extreme aggressive arguments in favor of their position and leaving it up to a judge to parse out what's true, what's not true, and what's in the best interest of the children, what's equitable. Um, it's much different. Okay, more about the role of the mediator. Like I said, the mediator is a neutral neutral third party in the mediation. Parties can choose to have their own attorney in the process, but the attorney's role would be to provide advice before and after the mediation sessions. An attorney could also be hired to serve as a review attorney to review the final agreement with each individual. Hiring an attorney, each party's decision to hire an attorney is up to them. It's according to their personal preference. There's no requirement that attorneys be involved. Um, the mediator does not represent either side in the mediation. Rather, they act as neutral third parties. They're facilitating the party's own negotiation. Divorce mediators' focus is to help each party better understand and communicate their individual and common interests. When the common ground is found, that's where you hone in on the agreement. Common ground is found, the parties better understand each other. They're more able to explore these reasonable options. Mediator is the one tasked with creativity, custom making arrangements, ideas that could fit these participants' circumstances. So to sum up, without taking sides, a divorce mediator helps a couple come to an agreement that meets their needs and circumstances. A divorce mediator encourages the participants to communicate their needs and their interests so that the participants can find common ground, gain perspective, and make informed decisions in order to come to an agreement. Okay, so that's what the mediator does. What do the parties do? They are voluntary participants. I said this before, it's voluntary. There is no mandatory mediation in divorce, and the process is unlikely to even work if one or both parties are unwilling to participate. The parties are engaging in a cooperative decision-making process. They're working together to come to an agreement. They need to communicate their thoughts, feelings, and preferences, as well as understand the other person's perspective. The role of the parties also includes disclosure. If you're going to voluntarily participate in this process, it is mandatory to disclose your finances. You have to be forthright and forthcoming with the information as far as your income, assets, debts, tax liabilities, etc., in order to complete the mediation. Parties also are tasked with keeping an open mind. Mediation, as I've mentioned, can be a creative process, a custom-made process, and therefore some of the options that are available to parties are going to go beyond the traditional courtroom outcomes. You're not thinking about what would the judge award me in this case. You're thinking about what would be right for my family and my spouse. Okay, so how do we complete the mediation? When all the issues are resolved, mediation is complete. Divorce mediation does not result in a divorce. That might sound illogical, but that is how it goes. When a mediation is complete, that means all the issues are resolved. Mediation is the process by which parties come to an agreement on the issues necessary to get divorced. The next step, once all the issues are resolved, mediation is complete. Now it's time to prepare an agreement. An agreement, in order to be enforceable and valid in the courts, a divorce agreement must be written, signed, and executed in a manner sufficient for a deed to be recorded. So it needs to contain the correct acknowledgments page. It needs to be acknowledged before a notary. There's very specific language that goes into it for it to be formally executed. The mediator could be the individual who prepares that agreement, but not necessarily. The formal agreement also contains, will contain a lot of boilerplate. We call it boilerplate, but it's really, required language. There's language that must be included in a final agreement pertaining to the disposition of parties' wills and estates, um, as well as recitation of the Child Support Standards Act, presumptively correct calculation of child support, as well as the notice of guidelines maintenance calculation. So that is the formal agreement. Compare that to a memorandum of understanding, which is really just a mediator setting forth, maybe in bulleted type, an outline of all of the agreements that the parties have come to pertaining to each issue. Review counsel, parties can hire an attorney. I think I mentioned this. Parties can hire an attorney to review the final agreement. Filing for divorce, parties are not divorced until they obtain a judgment of divorce. So, you've completed the mediation. You don't necessarily have an agreement yet. You fully execute that formal agreement after it's written up and approved. You sign that, you're still not divorced. You have to take that agreement and you file it along with other paperwork to obtain what's known as an uncontested divorce. And I think I spoke about this before as well. There are considerations for delaying the divorce. The primary reason is for one spouse to remain on the other's health insurance. There's also, some tax planning that can be done as far as remaining married for one or through the end of the year for another year to maintain that joint married tax benefit. Okay, so filing for divorce. In order to file for divorce, I said this, you need a fully executed written agreement. The parties can choose to have the mediator prepare the agreement, or they could have another attorney prepare the formal agreement. If the parties decide to have another person and another attorney prepare the formal agreement, that's when the mediator would prepare that memorandum of understanding that I talked about. If the parties haven't started the divorce process yet, the agreement would be called a separation agreement. This means the parties will be officially separated but not divorced. And that separation agreement could then subsequently be filed along with the uncontested divorce papers. So in order to file for divorce, you file an uncontested divorce packet. The packet includes some affidavits both parties have to sign attesting to basically the grounds for divorce, jurisdiction for the divorce, and some biographical information, as well as the proposed judgment of divorce and the findings of fact and conclusions of law. The judgment of divorce is going to reference the parties' written agreement. It's going to incorporate but not merge the written agreement, and that makes the agreement part of the judgment of divorce. It is enforceable as a court order, as though it were fully set forth in the judgment of divorce. Who will be the plaintiff? That's really an arbitrary decision. It's really that is the person who is retained by the attorney who is filing the uncontested divorce papers. And that speaks to the next bullet, the role of the mediator in obtaining the divorce. The mediator does not play a role in obtaining the divorce. The mediator's job is done once the agreement is prepared or the memorandum of understanding, if the parties are going to elect to have someone else prepare the agreement. So whoever is the plaintiff is the person who basically pays the retainer fee for that attorney who's going to file the uncontested divorce papers. The parties could agree to split the cost, or one party's going to pay for the filing attorney. In any case, it is going to be much cheaper to retain an attorney to file uncontested divorce papers versus retaining an attorney to potentially litigate a contested divorce case. Once you have that signed agreement, there's really nothing that can be done other than file that agreement and request an uncontested divorce. So any attorney is going to know that this is a fairly straightforward process, just filling out some forms and collecting some affidavits. As far as timing, it's hard to say. Obviously, with the COVID pandemic, that's still affecting the courts. It's gummed things up a little bit, fairly significantly, caused some delays. And even prior to the pandemic, the timing of obtaining that judgment of divorce varies widely, depending on what county you're in. Typically, it's going to be, I'd say, under normal circumstances, I found 6 to 8 weeks, a couple of months. Once you file all of the papers and it's uncontested, it really just needs to make its way through the clerk's office and then assigned to the reviewing judge who, signs off on the judgment of divorce. Okay, so to recap, divorce mediation is one of several types of alternative dispute resolution. Mediation is appropriate for most couples, I'd say, but not all couples. There are very specific circumstances where it is, in fact, not appropriate. Mediation is often less costly than divorce litigation. It's less costly on several levels, financial, emotional, and also your time. The mediation process it places the mediator in the role of facilitator, neutral third party, and the participants are the communicators. They're expressing their preferences, their desires, their interests, and they are ultimately the decision makers. They are working cooperatively to make decisions that they feel are in the best interest of their family and are most appropriate for their circumstances. A mediation is complete when the parties have resolved all their issues. Sounds straightforward, but if you're thinking mediation is complete when you get divorced, that's not how it works, right? So mediation is complete when the parties resolve all their issues. The next step, once you've resolved the issues, is to take those resolutions and turn them into a written agreement or a memorandum of understanding for the mediator. But ultimately, the parties need a written, signed, and duly executed agreement, a separation agreement or a stipulation of settlement. And the final step is to submit that signed agreement along with the uncontested divorce papers to obtain the judgment of divorce. All right. Well, it was great to share with you today about mediation. I think it is a viable solution for most people in going through a divorce. Divorce is hard enough. You don't want to leave it in the hands of a judge to decide your fate. And you don't want to have to be put in the position to score points against your spouse. Although you might want to resist the urge, consider mediation. You'll end up with a more durable agreement. I can attest to that. So with that, I am going to stop sharing my screen.
Thank you everyone for joining today's presentation, and thank you, Michael, for presenting. Today's presentation was recorded and a copy will be sent to all attendees. I hope everybody has a good rest of your day. Bye.
Thank you.